Hey everyone, James Willis from Daly Black here. Today we're going to talk about the issue of the burden of proof, and we're going to ask the question, whose job is it to prove that loss or damage to property is excluded under an insurance policy? And the answer to that question is always the insurance company's job. It is their burden of proof to demonstrate that coverage is not afforded to sudden and accidental loss or damage to property. Now, the way this plays out in the field is that oftentimes the insurance adjuster is going to try and tell the policyholder, the public adjuster, the contractor, or the homeowner that they have to prove that something is not excluded. And that's never how it works. At Daly Black, we understand that things are not going to necessarily play out in the courtroom the way that they are practically out in the field. But we're always thinking ahead to trial, and we're thinking about how the jury is going to be asked certain questions. Section 554.002 of the Texas Insurance Code requires that it be an insurance company's job to put up proof in a courtroom to show that some exclusion under the policy applies to sudden or accidental loss or damage to a property. Take this example. Imagine that somebody has a water leak in their house. If you own a home, this is eventually going to happen to you. If you have homeowners insurance, it's probably covered under the policy if it's a sudden and accidental discharge of water from a plumbing or piping system. Now, the insurance adjuster might come out to the property and he might say, well, that's covered, but if the water leaked for more than 14 days and that caused damage to your home, that's not covered. So, Mr. and Mrs. Smith homeowner, do you have any proof or evidence that this water didn't last more than 14 days? Now remember, it is always the insurance company's job to adjust the claim. It's never the homeowner's. It's not the homeowner's problem to show whether or not the water lasted more than 14 days or less. If the insurance company wants to exclude damage, and if they're not looking for coverage as they're normally supposed to do, it's their job to prove that the water lasted for more than 14 days. And if they can't do that, then they can't exclude the damage. The other issue where we really see this coming up in the practice of first-party insurance litigation is with the hot-button issue right now in the industry, the cosmetic damage exclusion. Everybody has seen this out in the industry. A hailstone comes down and it damages a standing seam metal roof. It might cause giant dents within the standing seam metal. It might bend the standing seams along the edge of the roof. And while this might not be limited to the mere appearance or the cosmetics of the metal on the roof, the insurance adjuster will say to the homeowner, public adjuster, and contractor that they somehow have to prove that the damage affects the functionality and the intended functions of the roof to shed water. Remember, it is not the homeowner and the policyholder's job to prove that. The way this will play out later in the courtroom is that it will be the insurance company's job to prove that, and the judge will instruct the jury as such. We'd love to educate you more about these burdens and how these exclusions are playing out in the courtroom in Texas. If you ever have a question, give us a call. Thank you.